subscribe to our channel and press the bell icon to never miss a video from LiveLaw.
Hello everybody. We are joined today by Professor Dr. C. Rajkumar, who is the founding Vice Chancellor of OP Jindal Global University. We also have with us Honorable Mr. Justice Michael D. Wilson. He is a Judge, Supreme Court of Hawaii, and Honorable Mr. Justice Matthew F. Cooper, who is a Judge, New York County, Supreme Court, USA. Thank you so much for joining us.
Thank you. Thank you for having us.
So the theme for today's discussion is democracy and judiciary, comparative perspectives from United States of America and India. So let me begin the conversation by asking this broad question, which is, in your experience, how do you view the role of the judiciary? How has it evolved over the last few decades, especially now that both USA and India are, they're welfare countries, they're going more beyond the limited role of dispute resolution. So how do you see the evolving shape and role of the judges and the judiciary in USA and India? Justice Wilson, if we could start with you.
I'm happy to. And can I call you Avani?
Yes, please.
All right, thank you. I would say that in the United States, given the development of the law in the last few decades, that democracy and the judiciary depend upon an independent judiciary. And as time has gone on in the United States, it's really served us well, particularly when it comes to the disadvantaged part of the population, the poor part of the population, who need their individual liberties, such as the right to privacy, the right to be free from unreasonable search and seizure by the government. So what does that mean? If you have an independent judiciary, if the government, represented perhaps by police authority, attempts to arrest an individual and they don't follow the law that protects the individual freedoms of the individual, then the independence of the judiciary is asserted in order to make clear that the government cannot take that kind of illegal action when it comes to taking somebody's freedom away or illegally arresting them. So I would say judicial independence has been something that's really helped define the courts in the United States, and particularly at the level of the United States Supreme Court.
I think there are very shared experiences of both our countries. Both India and United States have a very long tradition of democratic governance. But it is only, appropriate to say that at the founding moment itself, when our framers of the Constitution were debating about the kind of republic that we were establishing, they were very conscious of a few things. One was that they were recovering from colonial rule, and they were conscious of the use of power by power holders. So they ended up creating a very strong fundamental rights provisions, elected state policy, recognizing that governments there should be checks and balances for governmental exercise of power. Second, of course, they were conscious of the fact that you need independent institutions which should make the functioning of the government effective. And while they were creating a structure whereby legislature and executive judiciary would perform its own roles and responsibilities, they clearly recognize the unique role of the judiciary when it comes to not only dispute resolution, but also ensuring that all the branches of government are acting in accordance with the Constitution. That role of interpreting the Constitution and upholding the rule of law and ensuring that the branches of government are in adherence to the Constitution, that was clearly vested with the judiciary. Of course, in more recent times, if you look at the evolution of the judiciary itself, it has gone through phases of more conservative and timid, way of functioning just after independence, to the post-emergency, particularly the emergence of a more activist court focusing on public interest litigation and how it can assert its role, and to a larger extent, more recently, looking at functioning of the government and making the government institutions accountable to the Constitution as well. I must say that these are some of the fundamental expectations on the part of the judiciary. It is no longer the judiciary can do it as a matter of choice. The people expect it, and I would say the Constitution of India expected the judiciary to perform its role. So unlike, for example, the United Kingdom, where the parliament is supreme, in the Indian context, it is not just any of the institutions, but it is a constitution which is supreme, and judiciary is vested with the task of interpreting the constitution and determining when other wings of the government, go astray and indeed undermine the constitution.
Okay,
Justice Cooper.
So this is my first visit to India, and besides being just amazed by what a wonderful, vibrant country it is, I'm also struck by the similarities between your system of laws and our system of laws, where we are the oldest constitutional democracy. You are the largest constitutional democracy. I understand there's certain provisions of our Constitution that are mirrored in your Constitution, particularly our famous 14th Amendment and your Article 21. And of course, both preambles are the same. They begin with "we the people." But I think one of the things that defines the role that the judiciary plays under our system of constitutional law is "we the people" doesn't mean we the majority. It means we all the people. And the key role that courts have played, amongst other things, as Chancellor spoke, there's the separation of powers and the checks and balances, but one of the key roles of the judiciary in interpreting a constitution is protecting the rights of all the people, not the majority, all the people. We've seen courts be it's fallen upon the courts, and I think in both our countries, to be there to protect minorities from majorities.
Now, a common thread that I picked from all of your responses is the independence of judiciary. You, Justice Cooper in particular, raised about this point about protection of minorities, but Justice Wilson, you raised a very important point about independence of judiciary. Now, in India, recently, there was this entire debate when a sitting Supreme Court judge made certain remarks about the Prime Minister of India in an international judicial conference. I'm trying to understand from all of you, what's been the culture like in America, what are the limits where the judiciary and the executive interacts? Is it popular? Is it usually common for judges to have their views on the government officials aired out in public, or is there more restriction? Do you see pros and cons of it? So this kind of balanced approach between the judiciary and the executive, what's your view on it? How do judges see it, and how should they see it?
Well, Avani, you bring up a really important nuance in the culture of the judiciary, a kind of area that many people don't necessarily notice until there's a very important issue. And that nuance has to do with the extent to which a judge is able to comment about a public issue, and the extent to which a judge is able to personally have a relationship with a very important member of the political system, perhaps a prime minister or a president. So while that nuance isn't necessarily noticed by many, I appreciate that you do, because it is one of the core protections of democracy and the rule of law, because there's got to be independence. And the appearance of impropriety is recognized as a very important concept. So naturally, it may be that many times members of parliament know judges, or it may be that at times there are judges whose family or family members know other family members. But it's really important, therefore, to be conscious, as we in the United States are very conscious about having no relationship necessarily if there's a case that's pending. Otherwise, though, there are interactions that take place at official levels a lot, right? At different conferences and that type of thing. But if there is a case that could come before the court, that apparently could come before the court, like a high court, or there's a case that is before the court, like in the United States at the US Supreme Court, or at a Supreme Court level of the state, then we are very careful to have no contact with the parties or any members of the family of the parties or the businesses, of course, that are involved in the litigation. So yes, although a lot of people don't think about it, it's really an important concern, and it's something that judges have to be trained about to understand where to draw the line.
So, I mean, Avani, it's a fantastic issue that you're raising. And, well, first of all, we should remember that the concept of independence of judiciary is not only about the need for strengthening the institutional capacities and the functioning of the members of the court. It's also an important signaling for the community at large, for the public at large, that the institution is actually functioning in an independent manner, and the judges are expected to function in an independent manner. And independence, both not being influenced by things that are happening around, and possibly the people who are holding important positions of power and responsibility. So the point of and that's, while I say that, we also should be conscious of the fact that in any sort of democratic and open society, it is possible for members of the judiciary, or for that matter, people in the government, to have broader social interaction. And those social interactions might have people making certain statements and observations. So it's a very important distinction that we need to make, that it is not that every possible comment or observation or statement made by a judge needs to be microscopically evaluated and assessed, and then intentions imputed on them, because after all, we are an open society. Having said that, it's also important for us to, and judiciary is best suited to do it, is to make a very delicate balance as to how and what kind of statements and observations that they make as judges, what kind of signaling it does. And it's an internal, introspection, both individual and institutional introspection on this matter, because even without having any specific imputation of intentions on the part of any judge to have made observations, the question is this the right way of, what are the signals that you give away as an institution? And it may be entirely possible that you can, after that introspection, you may conclude that that was a social engagement, and a statement or observation made should not be seen any more than that. Nevertheless, it's something which we need to be conscious of. I also want to say that the reason in today's day and age, it's also about the media awareness. I mean, think about 30, 40 years ago, this kind of a statement or observation made in a social context may not have acquired the kind of prominence that it receives. So in a way, it's also important to mention that all of us, and particularly those who are in the public world, are hugely vulnerable, because we might willy-nilly have made a statement or observation without really fully be conscious of its potential implications. But now, more than ever before, everything that we say need to be measured. And that's an important aspect of that introspection as well.
Mm-hmm. So quite a balanced approach that Professor Rajkumar is suggesting. What are your views on this, Justice Cooper?
Well, actually, the way I'm elected, or the way I became a judge, and I just said the word elected, is much different than either the way Judge Wilson became a judge, and I think it's totally out of sync with the way your judges in India are selected. Your judges are selected, and some of our judges, and in the state of New York, where I'm from, not all, but some of their judges are elected. I am an elected Supreme Court judge. Before that, I was an elected civil court judge. So during certain periods of my life, in order to become a judge, I actually was a politician. I ran for office on the Democratic Party. I sought the support of various political leaders and would campaign with them. So that's a little different than I think you might, for the norm that you might have here. But the rule is, and it's somewhat a strange rule, because here you are a politician for seeking election, running for election, having election night, counting the votes. Soon as you become a judge, then you cease to be political. And there's certain rules as what you can do, what you can't do, and until you run again. Fortunately, I don't have to run again, so I'm not going to have to don the political hat. But it's important, though, that even though we have this process where judges might be elected in New York, they are seen as independent and they act independent. And so I wouldn't comment favorably on a politician publicly, certainly in my official position. Same token, I wouldn't comment negatively on a politician, but something to take to build on what Chancellor Kumar said is the perceptions are so heightened now because the media is so aware. It's interesting to note that during the New Deal, when Franklin Delano Roosevelt was president, he regularly, and Mike, you might remember this, he regularly had members of the Supreme Court come over every Tuesday night to play cards. And at the same time, they were deciding incredibly important issues involving policy and involving issues that the president was pushing. But the notion was that they would still act independently, that they wouldn't end up simply ruling for him because they had social engagement. But in today's world, with its heightened
imagine a photograph with
right.
the president playing cards with the Supreme Court judges in the U.S.
That is, with this world now, it would be the front page, FDR playing cards with Felix Frankfurter. How can you expect Frankfurter to be neutral? And so we have a different world.
Right, but speaking of notion, in India in particular, we've had a long-standing tradition where common people perceived that judges are best suited to appoint judges. So as far as the Indian appointment of judges is concerned, it's largely been a judges dominated affair. Up till now, where now there is an entire debate around whether the system should open up and is letting judges alone decide who should be appointed as judges the best thing to do. So the government tried to pass a bill wherein it tried to bring some government representatives on board and tried to create a balance between the government representatives and the senior most judges in the Indian Supreme Court appointing judges. Just quick thoughts on if you think and if you have your experience of what works, especially in today's context. So yes, there was a time. Now times have changed. So now moving forward, where should and how should India look at this entire thing? Thoughts of it based on your U.S. experience?
I would simply say that is a debate that has gone on my whole life, and I believe will go on forever and ever. In New York State, the state I'm from, as I said, some judges are elected, some judges are appointed, and each side claims that this method might be better than the other. There's now more of a push to appoint more judges, but there are people who believe who else should have the final word on who their judges are, but the people themselves. There are other people who point out that it's too subject to politics, and that, try as you may, the voting public is never really going to know much about all these names that are listed on a ballot. That might be the question. I would come back with an answer. I just don't know. I really don't know which system works. Your system is where I guess judges do the appointment. Sounds interesting. How well it works, I don't know.
Justice Wilson.
Well, although I am always interested to hear what Matt Cooper has to say, because not only because I learn a lot from him, but he's wildly entertaining. I do have a disagreement here. Because if you consider this question that you're asking, elected versus non-elected, India's system of judges appointing or an elected system, it raises a question, what kind of a democracy are you talking about? In the United States, naturally, we have a good educational system. We have a strong democracy from the point of view of a lot of discussion, a robust media, but there is a concentration of power in the world like that has never been seen before. The economic might of certain organizations, you could, if you relate it to Rome or some of the periods of great empire, you could say that the power exercised by these organizations could eclipse an emperor, perhaps. So how important is it for there to be a recognition of the influence of very important organizations on the democratic process and perhaps individuals that are going to vote? how much do special interests somewhat control that process in a way that, as Justice Cooper rightfully pointed out, doesn't necessarily serve everybody. Take an example. What is the issue now that is so critical to a minority and a relatively powerless minority, but is inescapable for India and the world? Young people. Climate change will mean that 160 million people are likely to leave Bangladesh and head towards India during the lifetime of people that are 40 years or younger. Well, do you want to have judges in a situation that are more independent? And if you've got an independent judiciary like India, where the judges are appointing the judges, the chances that special interests are going to get involved in the analysis of something like climate change is less, right? Because you have judges appointing judges and there isn't necessarily that kind of influence. And that issue is coming. And if you also assume, from the point of view of a healthy democracy, that when it comes, there's going to have to be a lot of, if you will, recognition of the rights of the poor, recognition of the disadvantaged, recognition of the people that are going to be most impacted, then it does mean that who's going to stand up for them? And I'll finish by saying, you know, I've been coming to India for 8 years. And when I came 8 years ago in particular, the demonstration of judicial independence that I was privileged to witness by, for one thing, a very independent Chief Justice of India was inspiring to me. And I think that India's ability to represent young people will have a lot to do with whether judges can comfortably represent them, right? Who's going to stand up for them? And it may well be that that tradition that I think is there with the Supreme Court of India will continue in standing up for the little guy, the poor guy, the individual that doesn't have economic power.
But what I do worry, and there's one quick part,
Yes.
is that, I don't know, and my friend Michael definitely brings a good point, that election of judges brings in politics with a capital P and brings in money and brings in campaigns, and it can be an opportunity for a real pernicious influence. But I mean, our United States Supreme Court is not elected. It is appointed by the president with the consent of the Senate, but it is in a process that is as political with a small p as you can possibly find.
And that is what I want to ask Professor Raj, because you've seen the Indian system change. I mean, we had the 70s and the 80s where, you know, every person, a common person on the street would look at the judiciary and say, you know, we should all be for judiciary, appointing judiciary. But now, with the times changing, do you think there's a need for reevaluating the Indian position? Or do you think that on principle, Justice Wilson's point still stands true in the Indian context?
So I want to start by saying that Dr. Ambedkar, just after the Constitution was written, towards I think one of his last speeches, he spoke about the beautiful Constitution that we had written for ourselves. And then he said towards the end that, you know, after all of this, if we as a country, if we fail, it is not so much the Constitution that would have failed us. It is we, the people, who would have failed the Constitution. And he mentioned, he was referring to the power holders. So my first point on this is that it's not so much the system and the process and the procedure of the appointment of judges. It is really about the kind of people who are going to be involved in doing that, and to what extent they are going to be honest and sincere and maintain integrity and rectitude and keep in mind the constitutional morality and constitutional norms to be able to ensure that the best of the individuals are with unimpeachable integrity are appointed. Having said that, we have actually gone through an extraordinary evolution in our country of having the system that was directly, like the US current system, which is that the executive was involved in appointing judges and there was a consultation process. The consultation would involve engaging with the judiciary, but the executive appointed judges, and there is enough empirical evidence that some of the most outstanding judges that India has ever had came through the system, what we can loosely call politicians appointing judges. And then, of course, there was a clear moment when the judiciary took upon itself the task of doing that because they felt that something wrong was happening in that process, and it simply interpreted the constitutional provisions to recognize that consultation includes concurrence, and hence took over the process, and we've had very distinguished judges appointed to that as well. Now that the process of changing the method happened, we have to recognize, and this is something which we can all see, why there is so much of interest among the politicians to change the system at a time when there was enough political acrimony prevailing. The time when the National Judicial Appointments Commission bill was brought in, there was absolute consensus among politicians across parties to get that law passed. Not that I'm imputing intentions on the parties who did that, but the point is there is today, and regardless of whichever parties in power, there is a discomfiture when judiciary becomes independent and is able and is taking uncomfortable decisions. So we have to recognize that independence of judiciary is an absolute non-negotiable objective, and of course in India that has also been adjudicated as it is one of the basic structure of the constitution. So with that objective, we should seriously consider, and I have written extensively about it, and I am of the view that while the National Judicial Appointments Commission Act was unconstitutional and had to go, I also believe that the existing method of judiciary appointing judges to a large extent on the whims and fancies of judges themselves is not a healthy practice as well. Having said that, we need to now enter into a very difficult and a very serious conversation that should include civil society, it includes lawyers, and of course judges, former judges, politicians, and almost every segment of society to develop a framework that will enable our objective of having an independent judiciary, which will definitely involve a very substantive say in the process of the politicians. It should, of course, have a substantive say of the judiciary itself. Now, of course, in a country like India, when judiciary is involved in taking major decisions about laws and the powers exercised by the government, this is not going to be easy. But that's a difficult task. But listen, judiciary, for example, United Kingdom had brought out the Judicial Appointments Board, and quite remarkably, and I don't know whether you know this, Avani, but in that Judicial Appointments Board, there is not a single person in law. It's an entirely non-law board. No judges, no lawyers, individuals who are from other walks of life are in that. So in a way, we need to be looking at, we need to go into a more deeper analysis of how different systems are functioning effectively, and then to borrow and maybe even draw some of those experiences that will suit us. I have to say that given the fact that that will take an effort and time, it should come right now. It's important for us to have any form of system that will at least have the faith of the people of India in the judiciary. And at least in India, that becomes so critical, because if we lose that faith, we run the risk of undermining all our democratic institutions.
And let me follow up on that,
Yes,
because
please.
the idea of undermining the fate of the future in terms of democracy and the independence of judges does, and you're implying this, have to be seen in a cultural context. India is not the United States. But let's move to the United States for a moment.
Sure.
Imagine if we decided that we feel giving independence to judges, and we give extraordinary independence because federal judges are appointed for their whole life, not to 65, their whole life. So, given the political culture that we have, if we go to the Constitution, open up the Constitution for public input. As I said, an enormous amount of power that's been concentrated in the United States in a few entities is, of course, going to be present. And then the President of the United States will be able to participate in, of course, a very, very important way. So you could see how there could be some great apprehension among judges in the United States and citizens of the United States if we were to start opening up the question of the independence of the judiciary to see if it could be altered. So it does depend on where you are, I guess, in your kind of cultural moment.
Right,
in
but
different
just
countries.
following up on that, sir, one of my experience when reading the constitutional law at Harvard Law School was that one distinct feature of the way they teach constitutional law in the United States of America is that there's a lot of emphasis on understanding a particular judge, his or her thoughts, views on various subjects, and then kind of analyzing the judgments that they give on how that's influenced by their own school of thought. In India, while we do have critical analysis of the judgments, we don't really go that much deep into analyzing the judges themselves. So do you think that kind of culture has also shifted very much in the judges being more self-critical, more concerned about what their larger school of thought is, then kind of changing it from on a case-to-case basis? Does that kind of analysis in the legal education system itself helpful for this entire process of judicial independence?
You bring up a breathtaking change that's happened, right? Because you have the internet. You have the ability to Google. You can get so much information about the individual. And it begs your question, what if independence, and I think we all agree, independence is a good thing when it comes to the judicial branch of government. Does that mean that the reality that a judge's personal life can be searched at a very, very specific degree, does that mean that we should be more careful about judicial independence and the way that we pick judges? And I would think that, my view would be that we, of course, need to make it clear that judges can be in a secure position where they don't necessarily have to make a decision depending on what the internet is saying, not just in their country, but around the world. Because an individual that makes a decision like the Prime Minister of India or the Chief Justice of India is an individual whose message certainly transcends India. I'm a judge of a state in the most remote state in the United States, and it's the most remote settled location on earth. But we pay attention to what the Supreme Court of India does.
So my quick question then, next one, we're talking about democratic processes, and I kind of think one obvious difference in the Indian and the American system is this whole concept of the jury system. Now, in India, we've not really for a very long time had a robust discussion on the need to introduce the jury system. And one of the arguments that kind of stalls this entire debate, right, even before we begin it, is that the level of education is relatively higher in the United States. But then there's also critique of the jury system as it prevails in America. That not everybody is educated, not everybody is sensitive. So then the jury system with itself brings in inbuilt biases. Right. So what's been your experience like with the jury system in America? And do you think, given your experience, I know you said you've come to India for the first time, but I'm hoping you read about the Indian legal system. And in your experience, do you think that that's something that India could consider, should consider?
That's a major difference in our two systems, because if you want to use a catchphrase of the American American judicial system, it would be the jury system is the bedrock of our legal system. And as a judge who's primarily been a trial judge, I have found the jury system to work. It has jurors, despite their level of education, despite their whatever they do for a living, come into court and are extremely focused, take it seriously. And I've had cases, especially in criminal court cases, where actually they were relatively minor crimes, and so nobody was faced with going to jail for any significant period of time, if at all. Yet the jurors spent 2 days deliberating because they wanted to make sure they got it right. And so the jury system plays a key role in our legal system. The problem, of course, becomes, that when things become hyper-technical in the world we live in, when you're dealing with some sort of commercial issue, that this may be beyond the ken of the average juror, but to some extent it's beyond the ken of the average judge as well. Some of these issues are so complicated. And I guess my final word is that on this is that the system has worked well in our country. Would you agree, Mac?
I would enjoy responding to that because it seems to me the most powerful force for good government and good democracy in the United States is the jury. Now, imagine we have the proposition that, as Justice Cooper said, India has too, that we have government for the people. The preface of the Constitution is being we the people. What are the fundamental structures within government in the United States to preserve that very critical concept of making sure it's government for the people, it's administered fairly, regardless of privilege or wealth? Well, you've got the division among the branches of government because they keep an eye on each other to make sure that none of them become significantly more powerful than the other, with the idea that we can't trust one of them to have all the power. And you also have the check and balance that comes from, in our case, the Constitution, because we have the Bill of Rights. But in many ways, all of that depends on how the law is enforced. When the law is enforced for the average citizen, not the big, powerful entity, the average citizen, how is it enforced in a way that's frightening? The law can take away their freedom. The law can take away their property. But we give that power in many ways to the jury. They decide when there's been a violation of the law that allows for the government to execute a person, take their freedom away, take their property. And as Justice Cooper, I did jury trials for over a decade. And I was also a trial lawyer. And I would say that I have reverence for the jury system. It's not one person, of course, it's 12. And let me ask you this. Do they have a job that they have to worry about like a judge? Judicial independence just begs the question, is a man or a woman that's a judge going to make a decision to keep their job or look good? That's always a danger. What about a jury? Do they care? Not really. It's not a job. They make their decision and they take seriously that the freedom of their fellow citizen or their property is at stake. And so I have seen things that make me try to communicate to the outside world what an enormously valuable, pure exercise of power it is. Because when you watch to see who does not want a jury, what entity does not want a jury? Is it the most powerful person? Is it the most powerful corporation? Is it the most powerful government official? I don't think you're going to find citizens that understand it saying, no, we don't want that power to exercise, right?
Well said, yeah.
Can I just add one thing, because I'm sure Professor Kumar has something to say about this, and I'm interested in hearing on the Indian view. But one of the other really beneficial byproducts of our system, and in my state, everybody has to serve jury duty. Judges have to serve. The governor of the state of New York, is that jurors, through that experience, and studies have shown this, come away with a higher opinion of how the system works. They come back with, by and large, they say, this system of justice works pretty well. And so it reinforces the citizens' confidence in the judiciary. So
Professor Raj, that really puts you in a spotlight because now, having heard the benefits of the jury system, I'm thinking, would you suggest that it is time for India to also consider this debate and probably have a jury system in India?
So our histories are different, and I think it's important to recognize that the American democracy, the jury system, is a bit of a facet of the Tocquevillian model of, democracy being a conversation among people. And I think it is only fair to say that while India faced 200 years of colonialism, the Constitution of India was an opportunity for the people to come together. But I think if you look at the last 70 years of the evolution of Indian democracy, we have pretty much we've been brought to the stage where there has been greater democratic decentralization, including democratization of power and the involvement of people in building this republic. And I think, and one of the facets of our own evolution is that we have been very successfully, quite rightfully, overcome the rules of locus standi, where, it was limiting in the past when it comes to people having access to justice. Today, more than ever, we've expanded the writ jurisdiction. We have invoked the epistolar jurisdiction, as some would argue. We've the public interest litigation, and in many ways, invocation of the fundamental rights provisions and directive of state policy in our constitution has democratized access to power, and in many ways brought people closer to fulfilling their aspirations to building a just system. So I don't think we need to have a jury system in India to achieve that objective. We are already seeing that. And as we look at evolution of our democracy, both in terms of our development of our literacy, as well as development of young people, one of the things which we should be conscious of is that while 1.3 billion people are us as Indians, 850 million people are less than 35 years of age. Indian life expectancy is 71, when most parts of the Western world will become older. Most parts of Eastern world, including China and Japan, will become older. India will be younger and younger for a longer time. This means a lot of young people, if given an opportunity to be educated, will also become more aware and conscious citizens who will be challenging and resisting authority, but also resisting abuse of power. So the thing, what a jury system does achieve, we could achieve by ensuring that our institutions are functioning in an independent and transparent manner. Right to information is a very good example. We have again thrown open the functioning of our democracy through greater transparency, while there are numerous challenges in that. So in some ways, there are several things that we have done which are in line with, once again, bringing the citizen to the center of the focus and to reimagine the relationship between the citizen and the state. And that's what these things do. And so we probably don't need a jury system to achieve that. We have our own histories and context, and we can do what possibly the objective of a jury system would be.
I have a temptation to follow up on that, but I think the jury system debate is a huge debate in itself. So I'm just going to...
And remember, one thing, we would certainly, even though Judge Wilson and I are great proponents of the jury system in our country, we would never be so presumptuous to say India should have a jury system. Two different countries, two different histories, two different legal environments. It is different, and so our comments are about our system, certainly not.
Absolutely. But Professor Raj is here with us, and OP Jindal has been ranked as #1, the topmost law school in India. So congratulations to you, sir.
Thank you.
And that sort of builds a foundation for my next very important question. What do you see as the role of education, legal education, sir, and also judicial training? Largely on the question of training, be that of the law students or the judges, in kind of shaping up this democratic culture and having informed judiciary or people in the legal profession. So how do you see a role now with OP Jindal having this rank of being a law school with a difference?
Thank you, Avani. Well, I must say that it's been an extraordinary journey for us, and there have been so many people who have been in supporting this cause. But I have to confess that at the end of the day, we have 1,600 plus law schools in India. And if you just focus on the national law schools, we have literally 25 plus of them. And then if you're very generous about law schools and legal education and the quality of standards, we are looking at not more than a few hundred law schools which are in line with maintaining minimal standards of quality, let alone any pursuit of excellence. So it is not an exaggeration or even an overstatement to say that the legal education in our country is facing a very significant crisis when it comes to quality. The Bar Council of India, which is the main regulatory body of legal education, has itself recognized this challenge, and in the last several years has attempted to ensure higher standards, even at times delaying or not giving recognition to law schools that they think are not worthy of that recognition. So, and I think the aspect of legal education, unfortunately, we have been very cavalier, indifferent, and possibly downright irresponsible over the years, because this is where it all happens. The future lawyers, the future judges, and even our ability of our legal system to render access to justice starts at the law school. And we have an even more serious problem where if we end up having mediocre law schools, churning out mediocre law graduates, then you can imagine what kind of a legal system we will create for ourselves, potentially mediocre lawyers, and I dare say mediocre judges. Mediocrity gets institutionalized if we don't take legal education seriously. And that is why it has to become the most important public policy and education policy priority of India. And I will say that both the lawyers and the judges and law academics should come together with enlightened thinking about shaping the future of our legal law schools, not just because of the fact that law schools should become good, and that's a healthy and good objective, but the ability of India to build a rule of law society and to ensure access to justice so that people still believe that law has some meaning in our country. We need to recognize and fix our law schools.
Thank you so much for saying that. On judicial training specifically, sir, and also on broadly legal education, what are your views?
Well, I have been a judge for some time now and have had the pleasure of going to many seminars and gone through some judicial training, because for 10 years I was a trial judge, and now I've been on the Supreme Court for about 5 years. So I say that to preface what I'm about to say that may not sound conventional. Now, I enjoy using Justice Cooper as an example for many things, but I did go to law school with him, and he might have been the smartest guy in our class. But I don't.
That is totally untrue.
But I don't think of that as a reason why he'd be a good judge anymore. He's somebody who cares about people, devoted part of his life to it before he became a judge, devoted a long part of his life representing people, not necessarily focused on making a lot of money. So what's my point? You could have, as we do in the United States, a handful of schools whose names are repeated over and over and over again as the best law schools. They don't necessarily produce the best judges, and they put judges on the Supreme Court a lot. And I'm quite concerned, frankly, about the United States Supreme Court in many ways, partly because I think, it's really important to understand, if you look at, for example, some of the extraordinary judges they have, Justice Ginsburg, Justice Sotomayor, these are people who, they're compassionate, they came from a pretty tough background too. So judicial education is important, but the judicial education should not be controlled by the entities that generally are really concerned about the law and have great influence, because the law is a conservative thing. Judges generally are conservative. If you're at a point in society where rights have to be recognized because rights are being abused, domestic violence, for example, if you have a system that doesn't have women as judges, if you have a system in which the idea of domestic violence is considered to be a family problem, you have a problem in society. So the training to me includes making sure that you reach out and see what the social problems are and have people that address the judges that aren't necessarily going to try to ingratiate themselves to the judges, that are willing to talk about the social problems that really add integrity and add a material sense of worth to the judiciary, just as much as making sure that all contracts are enforced, making just as sure that when a decision is made by the jury, for example, that it follows the law. Let's pay attention to the real business of the courts, which is justice. And so I am hopeful that our judicial training in the United States will become a little bit more oriented in that direction.
A famous American judge once was asked about what should be the qualifications of a good judge. And he remarked that a good judge should be basically a decent human being, and a few years of law school should not hurt him or her. So we should keep that in mind.
Exactly.
But Justice Cooper, do you think the attributes that Justice Wilson is pointing out to qualify a person as a good judge is something that can actually be taught as part of judicial training?
So actually, two things. I want to say
Sure.
one thing just about the law school education, because Justice Wilson and I went to a same law school, a little different than law schools of the time. It was pushed a lot of innovative ideas, especially the actual practice of law. Something I think and something that's been carried on by O.P. Jindal. It's training lawyers to be lawyers, not just to be academics. But it also had people who were really interested in doing transformative law that was going to make an impact. It's one of the reasons I became good friends with Michael, is that he was so passionate about rights and everything, and how valuable the law could be. And once I found he lived in Hawaii, that sealed the deal. Then I knew he was going to be my friend. But in terms of legal education, continuing education for judges, my state, New York, is very, very committed to that. The idea that lawyers have to go back to school, so to speak. We call it continuing legal education. I think you have it here as well. Just call it continuing education without the L. We have judicial education. And in fact, there's even an institute. We have a campus called the Judicial Institute where judges have to go regularly to hear lectures from both other judges and lawyers, other experts. And it's a great way to open one's mind, because if you've been doing this a long time, you need to know what's going on out there. The law changes. It's also an opportunity for all judges throughout the state of New York to come together and share ideas, and I think that's very important. But can we come up with, and the answer to your question, can you instill certain ideas that make you a better judge? Yes, that's a lot of what actually is taught there. How to conduct yourself on the bench, how to deal with the stress of being a judge. We deal with all those things. Plus, and I think we may probably end up talking about this at some point, how to actually run your courtroom. Because we can talk about how important justice is and how important the Constitution is and how important protecting rights may be, and how important, not maybe, it absolutely is. But sometimes we ask the regular person on the street, what do you want out of the judiciary? They're going to say, I want my case to be heard fairly, but I want it to be heard quickly, and I want it to be heard at as little expense as possible. So one of the things that we do in our Judicial Institute, we have really nuts and bolts courses on ways that you can be more efficient while still protecting one's rights and actually exercising proper discretion and hearing a case fully and fairly, but do it faster than you might otherwise.
Now that brings me to my final question in the interest of time, and I'm kind of consciously framing it broadly so that you could pick up aspects of which kind of respond to you and you want to respond on. Well, there are two sides of the coin, access and representation. Now in India, access to justice is a huge issue. While we do have something called National Legal Services Authority, where the government pumps in a lot of money and the lawyers who are enrolled with them are required to do pro bono hours, a broader culture of pro bono is largely missing in India, which means this entire access issue, people who have the money can afford the course, but those who don't can't really do anything about it. There is a major scope for pushing the pro bono reforms in India. So there is an issue of access. Of course, there is an entire question of overpendency in the Indian Supreme Court. And of course, I know the numbers are not comparable in the United States and India. But having said that, access is one issue, representation is another. So in Indian Supreme Court, currently we have 3 women judges, and there is an entire debate about just gender equality, both in the legal profession and in the judiciary. So access and representation, I mean, this is a major debate, and how do you think, what do you think is a major concern according to you? I'm not necessarily asking you to choose either or, but within this broader framework, what do you think are some of the issues that both India and America need to respond at the earliest?
Let me start. Well, there is no doubt about the fact that we have a tragic situation in our courts, higher courts particularly, of very poor representation of women. I mean, I think it is only fair to say that we need a radical reimagination of the appointment of judges into both the high courts and the Supreme Court of India with more women. I really don't care how we get there, we need to get them there. And I also believe that the existing collegium system, the way it is, will have almost no women serving in that on a permanent basis. And so long as that challenge also is not met, we will have lesser possibility of women coming into the high courts and the Supreme Court. We need to do that immediately. As far as the issue surrounding access to justice is concerned, I entirely agree with you that we don't have a culture of representation as we should be in a country like India, where there is a lot of injustices and a lot of people are wanting to have justice. Not to speak about the fact that there are 30 million cases that are pending in Indian courts. And it's very important that India is not a litigious society at all, unlike the United States, arguably. It's not so much that so many people are going to courts and so many cases are constantly going there. It's just that those cases which get in don't come out easily. So it's not like, an average in a year. In fact, Mark Galanter and my friend Jay Christian, both of them have written extensively about it. And in their studies, they have only argued and empirically that it's not so much that we are a litigious society, but that we have a major problem on the docket management as well, which I believe is also connected to legal education and judicial training and improving efficiency and methods. But also, over 50% of the cases that are pending in the courts are government is the litigant. So we need to really, let's have a serious dialogue between executive and judiciary that you cannot address pendency unless and until you develop a better policy when it comes to appeals. And now we see the type of matters coming. I can't believe that even high court judgments, where one would think that high court would have settled the matter on, and state governments are routinely prepared to go on appeal to the Supreme Court of India. Those things should be sparingly done, because each such matter coming before adds to the sort of pendency potentially. Last point I will say is that if you really want to promote access for people who can't afford, you need to build a culture of pro bono. And this culture of pro bono should not be limited to a charitable offering occasionally. It simply cannot only depend upon the National Legal Services Authority. We need to have no less than the Bar Council of India as the main regulatory body for legal education, legal profession to drive this agenda into the imagination of law firms, corporations with in-house legal counsel departments, with independent lawyers, into law schools. So in some ways, we need to permeate the culture of pro bono public interest lawyering at all levels. And I don't believe that it should only be restrained to some conscious individuals who need to do that. And I used to work at a corporate law firm in New York many years ago, and I've seen that although one can make a case that even the United States and other places, they should do more, but there is a lot of recognition of the concept of pro bono legal practice even among hardcore corporate law firms. We don't have that culture, and we need to build that. And sooner we do, it's better for the soul of the legal system. But more importantly, it also creates opportunities for young lawyers who may adopt pathways into the corporate careers in law, but will continue to retain a deeper sense of conscience and a sense of public interest.
Can I just say what
please.
Because what the Vice Chancellor has just spoken about, law firms having a pro bono commitment, I see that every day. One of the things I do is I handle divorce cases in the courts. Even though I'm a Supreme Court justice, for an odd reason, that's where divorces are heard. And many of those cases involve difficult custody matters, different family matters. And poor people who could not otherwise afford counsel, some cases can have appointed attorneys. Our law permits that. But what really works, really great representation, is when a big firm has a pro bono department that does this. And as Professor Kumar said, big firms, like the firm he was at, firms like Weil Gotshal, White and Case, Sullivan and Cromwell, what they do they participate in programs where their associates, who would otherwise be spending 5 or 6 years in the library before they're actually allowed to go to court, get to actually handle a case. All the way through, they get to have clients, and they do amazing work because this is the first real case that they've actually had to do. They are committed to representing their client. It benefits client, and it benefits the court. And last of all, as Professor Kumar said, it benefits both the lawyer and the firm because it is a great way for them to understand what it's like to represent somebody in court. And it also gives an understanding that even if you're in a big corporate firm, you're not just, other than your major corporate cases, there's a whole world out there of regular people who depend on our court system.
But not just the young attorneys, Justice Cooper, but in the American system, what I found very interesting was that even the final year law school students, under the mentorship of young attorneys, could take up these pro bono matters. So most law schools have a very rich pro bono culture, and that definitely is adding up to kind of the numbers that we need to promote the pro bono culture.
Absolutely, and then in New York, we actually require it. In order for the first number of years that somebody is a lawyer, we require, that's part of the bar admission, you have to do pro bono. So.
Justice Wilson, your thoughts on the final question?
Well, access to justice is a concept that's pregnant. And Dean Kumar was referring to this in his remarks earlier today. And the idea of aspirational, the idea of achieving justice or access to justice, or an authentic commitment. So if you look comparatively at India and the United States from the limited perspective perhaps that I might have, but in the United States, we do, I think, have a relatively sincere commitment to access to justice. And how would you measure that? And this brings me to India. And it brings up measuring access to justice. What would it look like? There was a famous lecture given in Hawaii at the University of Hawaii Law School by one of the most famous and well-respected US Supreme Court justices in history. His name's William Brennan. And he was a wonderful person, and he was an erudite judge, and he was very productive, wrote a lot of decisions, civil rights decisions too. And when he gave the speech, here's this little kind of shriveled man. He must have been like 80. But when he was speaking, it was like he was 30 years old. And one of the things that he was celebrating was all the litigation, because he was taking on this idea that the United States is a litigious society. Lots of lawsuits are filed. And he said every lawsuit's an endorsement of our system because it's a statement that people think they're going to get a fair shake. They get a chance for justice. Now, if you look at India, one area of access to justice that stands out in a way that's pretty inspirational is the public interest litigation, or, if you will, standing. How hard is it if you're a citizen claiming injury or claiming that there's a wrong that's in violation of the law? How hard is it to go to court? Easier in India than almost any place. When you, as we have had the great pleasure of being around some of the Supreme Court justices, see their perspective, they're not focused on this idea of preventing people from getting into court. It's kind of part of the tradition that we are proud, we listen. Even with suo moto jurisdiction, this remarkable opportunity for the court to institute a case on its own. But in the United States now, the appellate culture has a bit of a challenge in trying to accept the way that the India Supreme Court approaches access to justice, because there's many, many devices, analytical devices that judges use to prevent people from getting into court. They're not injured enough. They don't have a remedy that seems to be clear enough. Many techniques to keep Americans out of court. And we have a trend in many ways, especially at the federal level, that's different than India's, where there's this idea that you should have access to your court. And so I'll end my long-winded point by saying, what is the measure of whether you have real access to justice? Do you have a lot of cases? It's too bad the courts in India have so many cases, but that can be managed with the new kind of information management systems we have with the internet. It can be managed with teams that get together and analyze what are the oldest cases and how quickly they can be resolved. So I wouldn't throw the baby out with the bathwater. That's my point. Yes, I mean, maybe a lot more has to be focused on more judges, and certainly judges that are women judges. But understand that the way the system's working now, at least, it looks like the average citizen in India thinks at least they can get a fair shake.
But I'll just sort of make a quick point. I actually did a study where I tried to compare the pro bono culture at law firms, not just in the United States, in UK, India, but also some European and African countries. And it was shocking to me that even Magic Circle firms in the UK actually contribute less than 2% of their profits in pro bono, while they of course make a huge pump and show about it with respect. But also at the same time, the one distinguishing factor that kind of decided whether a firm would have a robust pro bono culture was what were the values of the leadership. So as far as the pro bono culture is considered in India, if we have the leadership, take note of it and have some top-down models, probably that could definitely speed up the entire
Absolutely, good point.
And I have to thank you at this point. You've all been very, very patient as reflected with the judges and Professor. Thank you so much for having this conversation with LiveLaw. I thank you very much.
Well, thank you.
Thank you, Avani, and thank you, LiveLaw, for being such a powerful intellectual discourse in the legal arena.
Thank you.
Aloha from Hawaii. That's what we say, aloha.
All right.
Bye from New York.
Thank you so much for watching. Thank you.
Thank you.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.